Good evening. Wishing you a very happy World Intellectual Property Day. Thank you for joining in today. It's a pleasure to host my first webinar in your presence. So let's begin. Today we will learn about how intellectual property has changed our lives through affecting innovation. Now, IP has definitely changed our lives, and how has it been able to do that is what we will look into today. A quick short introduction to myself. I'm Advocate Roshni Lachwani, the founder of the law firm Intellexsys Legal Solutions. We at Intellexsys Legal Solutions specialize in intellectual property rights across the globe. We also deal in information technology laws and business law as well. We are working ahead. What is innovation? Now, innovation could mean anything new or anything unique or anything that adds value to a product or service and makes it applicable for the customer or the end user. Now, in the picture, as we can see a person holding an umbrella to protect himself from the rainwater. And the other person is not only protecting himself from the rainwater, but is also collecting the rainwater as well as collecting it in a mug to use it for drinking purposes. So exactly that is what innovation does. Useful application of resources. Now, why do we need innovation? Now, innovation actually fills the gap between needs and existing needs. Now, innovation is very important in defining the progress of a company. Now, as a process, it requires effective participation of individuals from different sections or divisions of an enterprise. It could be from the marketing segment, research and development, management, finance, legal, even outside consultants, suppliers, outsourced component manufacturers, etc., and a whole lot of people. Now, how do we exactly measure the innovation in a particular company? Now, this is where exactly intellectual property rights plays an important role. It plays a very important role in measuring the intensity of innovation in a company. Now, how do we drive this innovation? We definitely know that people have a lot of needs, and companies are trying to fulfill these needs through new and improved products. But then there are many companies who can then develop the same innovation to fulfill their needs, like in the picture. Too much competition can actually cause an imbalance in the economy, leading to a standstill in the innovation because there is no motivation to innovate, and thereby it results in obsolescence. Now, what is intellectual property? We are here to discuss intellectual property today. And definitely, intellectual property, in short, is the creation of your mind. Now, let me share an example with you of the history of IPR. Now, in the 14th and the 15th century, the Republic of Venice, was engaged in mining and water arts. Now, Coffer as well as David, they report on how several engineers were granted special patent-like privileges by the Venetian government. The first known example was by Johannes Teutonicus in 1323 for a grain mill. And another example is Jacobus de Valperga. He received a patent or a special privilege in Venice in 1460 for a water pump. So basically, as long as Jacobus lived, no one could imitate Jacobus's water pump without his permission. Now, basically, on the other hand, there was also an existence of a compulsory licensing provision, which basically required Jacobus to grant licenses to anyone who offered irreasonable royalties. At this time, Venice had two types of privileges. We have the invention privilege and the trade privilege. Now, the invention privilege basically gave protection from unlicensed imitation, while a trade privilege gave protection from competition. Now, thus we see that IP has been protected since ages in various ways, and it's not some recently developed legality. Now, what is intellectual property rights? It is an umbrella term for multiple intellectual property rights. It provides the owner of such legal property rights that the right to exclude all others from commercially benefiting from it. In other words, basically, it is a legal right that prevents others from using your creation for any kind of commercial purposes without your prior consent. Yes, let's look at the different types of intellectual property rights under this umbrella term of intellectual property. Now we have copyright. Now, copyright basically grants a protection for 60 years plus the author's life to multiple things like literary works, artistic works, dramatic works, musical works, and cinematographic films and sound recordings. So, in short, it gives protection to books, music that we hear, then we have scripts, we have films, we have dramatics, and we have a lot of paintings that are being protected under copyright. Then we have trademark, which is for smell, touch, sound, word, device, different type of trademarks. As you can see, Nike, McDonald's, Gucci. It helps you to differ the products and services from that of the others. It gives you perpetual existence or protection with renewal every 10 years. And then we go up to patents, which is utility, process, and product patents for different kind of products, processes, or utilities that develop, which have to fulfill the patentability criteria, that is novelty, utility, industrial applicability. It gives the protection for 20 years of an exclusive right to use, make, create an invention, and distribute the invention and commercialize an invention. Now we have design. We have different types of design patents, which are the shapes and the artwork. It provides protection for 10 years plus a 5-year extension on renewal. Then we have geographical indications, which is your Darjeeling tea, Nashik Valley wines, Nagpur oranges, etc., which come under geographical indications. They basically help you identify the origination of a particular product. And this also provides the same protection as of that of trademark, that is, it has perpetual protection for every 10 years on renewal. Then we have what we call as traditional knowledge. It's something that we have, the knowledge which has been gained because of traditions or from our previous generations, which is through yoga asanas, the healing properties of neem, tulsi, and turmeric. Then trade secret remains protected so long as it is confidential. So, for example, Coca-Cola is the world's most guarded trade secret, as well as the KFC recipe for which also comes under trade secret as well. Their trade secrets are highly valuable. Then we have plant varieties. Basically, if we come up with any kind of new hybrid variety of plants, or if we invent any different kind of plant variety, or if we have found a new seedling, then that could be protected under plant variety and give you protection for growing those particular type of plants for a certain number of years. We look into a video that can help you understand exactly how intellectual property rights and why intellectual property rights is important in this case. let's move on to some famous examples. We have the trademark examples such as Microsoft, Coca-Cola, and McDonald's, Nike, KFC, and the Apple logo. The copyright examples for the Spider-Man comic books, the design examples for the Apple screen layouts and the Crocs shoes. You can see the infringing copies as well. Then we have the patent examples for the Mundial scissors, Alpargatas shoes, aircraft passenger seat, which have already expired. And then we have the geographical indication examples such as your champagne, starting from the left on your right hand side below corner, which is Roquefort cheese next, and then we have the Darjeeling tea, and then we have Shanti. So these are some of the few examples where an IPR has been used to protect their innovations and thereby commercially benefiting them in a huge way. Today they are one of the biggest brands in the world, and thus IPR has definitely helped push innovation. As we also have seen in the video earlier, IP is very important to protect certain ventures and certain innovations that are required. Otherwise, they get copied, and then you can lose out on your commercial gain. Innovations have changed our lives, haven't they? Now, which innovations can you name that surround your daily life, or any innovation or inventions that you can't go throughout your day? Now, there are few cases where a strong IP regime has not only coexisted, but clearly fostered the emergence of a new leading-edge industry. Now, intellectual property protection is critical for fostering innovation. Now, without protection of ideas, businesses and individuals would not be able to reap the full benefits of their inventions and would focus less on research and development. Now, before moving on to that, I'd like to show a short video on IP and innovation, and how innovation from times when it began has been able to change our lives, and how IP has added its own value to that. Now that we've seen the video, we know how IP has actually added value to each and every innovation or each and every discovery that has taken place, and how it has made a special place in changing the way we live today. Now, let's look at the telephone. Now, the telephone has changed our lives, bringing the world at just the touch of a few buttons. Now, but did the first to invent get to claim his profits? Let's have a look. Now, we know Alexander Graham Bell is the father of the telephone. After all, it was his design that was first patented. However, he was not the first inventor. It was Antonio Meucci who began developing the design of a talking telegraph or telephone in 1849. Now, there was always a dispute regarding the same, and many yet differ their opinion on who was the actual first inventor. However, if Antonio Meucci was the first inventor, he definitely lost an important opportunity in the history of events in the world purely because of no valid existing proof to claim first to invent. Another invention, which is electricity, has made life so comfortable through, providing us the comfort of the fans, your light, your air conditioners, charging points, etc. But Franklin never patented in his invention. He very nobly wrote in his autobiography that as we enjoy great advantages from the inventions of others, we should be glad of an opportunity to serve others by an invention of ours, and this we should do freely and generously. So he freely and generously gave the discovery of electricity to the world. Although the art of generating electricity was patented by Thomas Edison in 1893, which is almost 103 years post his death. Now, definitely a loss of huge opportunity for both the discoverers, purely for their personal reasons and their personal choice, and therefore they were left with no gain. A very important song that has changed the way we celebrate our birthdays. I'm sure everyone is very surprised to see this here as an innovation. But recently, the court has ordered for the fee that Warner and Chappell have collected over the past 20 years, which is coming up to be $14 million, to be collected back. Why so? Because it has become generic. It lost its importance as an IPR. So only applying for a copyright in this case doesn't end our responsibilities, does it? It goes much beyond that. See, we definitely know that copyright exists the minute you create it, but only for you need to have proof of that creation. Now, definitely in this case, they did have a proof for creation because Warner and Chappell acquired the song's last publisher since 1988. They had control over the song. The song has been used commercially over 20 years, and over $14 million of licensing fees have been paid to use the song. However, now it has been asked to be settled, and the fee collected has been asked to be returned. Now let's watch a small video as Good Morning to All song that was created by the two sisters in 1800s, to which Happy Birthday to You traces back. Now that we have seen the Happy Birthday song video, we definitely know that the Happy Birthday song traces back to Good Morning to All, which was the original version of the song, which was owned by the two sisters, Patti Smith Hill and Mildred J. Hill. Moving on, the World Wide Web, a very important invention because of which we are having the webinar today. And the World Wide Web has brought the world closer in terms of both personal and business relationships through email, internet, Wi-Fi, etc. Also introducing these innovations and connecting us today. Now, of course, Tim Berners-Lee did write the initial proposal for the World Wide Web, and he did create the first web browser. He had a strategy to innovation, and he did not patent or restrict the technology, because if he would have patented or restricted the technology, they would likely have died and been replaced by something similar. Now, all the pieces were already out there. So once he would have patented it, somebody would have, tried to use a different technology or a different protocol to create the same result. So, you can patent technologies, but you can't patent concepts as such. And in this particular case, the concept was revolutionary. It is very important to understand a strategy behind an innovation and accordingly, incorporate an IPR to it or not. It is very important to understand that IPR is a tool to progress innovation and not to regress innovation. So always a strategy behind an innovation is very important to understand before applicating IPR to it. Let's look at the next invention, which is your motor car. An amazing invention and an amazing discovery of the wheel that led to this. An innovation that has helped us travel the world today and in so much ease and comfort that it was protected enough to cover their entire costs of research and development. On January 29, 1886, Carl Benz applied for a patent for this vehicle powered by a gas engine. Now, this patent may be regarded as the birth certificate of the automobile. In July 1886, the newspapers published the three-wheeled Benz patent motor car, and I would definitely like to say that the success of this particular motor car was solely because of the monopoly of the use and make, which was granted to Carl Benz for the limited number of years during which they could recover the costs incurred in bringing about this life-changing innovation. Christian Huygens developed the pendulum, which made primitive clocks, more accurate. But then we had Noble Jerome, a talented clockmaker, who received a U.S. patent on clocks made of brass in 1839. Now, why did he receive a patent for a clock made of brass? Now, it's an item that helps you to keep a track of your time and restrict your activity accordingly. But unlike wooden clocks, brass movements were unaffected by humidity and they could be easily transported by ship. Now, the entire world of clockmakers realized the potential that this clock had. And, it illustrates the impact of his innovation. Now, when the first clocks arrived in 1842 in England, the English customs inspectors assumed that Jerome had set the figure, far below cost to avoid paying the proper duties. And to teach Jerome a lesson, the inspectors bought the whole shipment. And when a similar cargo of the same valuation arrived a few days later, they did the same thing. And then they realized that they were actually becoming distributors for Yankee clock manufacturers. Now, Jerome was content with the prices British customs agents had been paying him and would have happily supplied them indefinitely. From then on, Jerome's clocks entered the English market unimpeded. Over the next 20 years, in part because of American competition, the British clock industry declined to near extinction. This is exactly what intellectual property rights can give you: a huge payback for your best inventions and for your best strategies. Xerography. Today's businesses, and not only businesses, but even students, individuals, government, are dependent on xerography, that is, photocopying mechanism for maintaining files, data, etc. Xerox today has become a generic term, given its lack of interest in claiming its right to word protection globally. Now, further, it would be fair to suggest that the existence of a patent, held by Carlsen, significantly contributed to Haloid's company's decision to support the invention. The most potentially innovative ideas, they always end up in the valley of death. An invention often needs external help, in terms of funding, technical knowledge, marketing, etc. Now, IP ownership in this case plays a very important role in influencing the decisions of external partners as to whether to assist in navigating through the valley of death. Now, only those ideas which are protected by IP most of the time stand a greater chance of surviving this valley of death. So thus, IP is also important in helping you to cross a certain point to commercialize your particular invention. We have aspirin. Now, it's a life-changing product. It has helped billions overcome pain, knowing that patents have a limited duration. The Bayer company embarked upon promoting a trademark for its new product. Why trademark? I mean, how does it extend your patent protection? Let's have a look. Now, today, over the counter or in subscriptions from doctors, aspirin is asked at over the counter, or it is recommended by a doctor simply out of habit. And the brand recall value, a very smart move by aspirin. Now, when the aspirin patent expired, the company continued to benefit from the sale of aspirin through its established trademark aspirin. Now, the Bayer company has been using this true track IP strategy, that is using a trademark to protect market share after the expiry of a patent for its Cipro product as well. Next, we have Coca-Cola, the world's most guarded and valued trade secret. Coca-Cola could have actually lost its secret formula through patents and would have probably not survived beyond 20 years. A very smart move by trade secret protection to its recipe, and it has been guarded for more than 100 years, being unable to reverse engineer the recipe in itself. Now, the company founder, Asa Candler, actually initiated the wheel of secrecy that surrounds the formula in 1891 as a publicity, marketing, and intellectual property strategy. Now, thus, it has been able to reach the stage that it has today. We would also like to mention about the other intellectual property rights of Coca-Cola. As we can see, the different type of bottle shapes from 1899 to 1986, the different bottle shape was granted a design patent and thereby has now become a trademark due to its strong recall value. Then we have the ribbon-like structure of the logo, which has also been granted a protection. For example, if any other brand uses the same design of the logo, that is the ribbon-like font of Coca-Cola, it can cause a confusion to an extent that it has been manufactured by the Coca-Cola company. Now, this is exactly how intellectual property rights can shape your brand and product, thereby affecting your consumer market. Moving on towards the last few slides, do we need intellectual property rights? We have different stages of innovation as we have laid it down here. At the first step, you have thought of an idea and are conceptualizing that idea to formulate a product or a prototype. At these initial stages, if you discuss your idea or concept with another, it could be a vendor whom you are planning to tie up with. There might be a possibility of the idea being leaked and developed by an already established firm in that field of work. Now, again, when a product is ready for launch and you have finalized a list of brand names and you're planning the execution of the launch, so you're discussing the branding and the entire plan with multiple parties. So there is again a possibility of the information being leaked before the launch, or the leak of a brand name, or applying for a trademark and thereby causing a loss of business if it is launched by another party in the same brand name that you had planned. Now, the same thing could occur again when an improvement is being made or when you are planning a different marketing or an expansion strategy. Thus, intellectual property rights helps maintaining a monopoly for a limited term in an already existing heavy competition. That's why we need IPR, and this is exactly when we need IPR. Little detail about why we need IPR. We think that innovation is a self-motivated process, but what about the high research and development costs which are involved to achieve this process of innovation? And what about the huge amount of time and effort that is required to be given to the entire process of research and development? Now, how does this effort of an inventor be repaid or rewarded? It's very simple. It's exactly through intellectual property rights. Now, intellectual property rights provides you with restricted monopolistic rights towards your invention, protected against a highly competitive environment. So had it not been for intellectual property rights, the efforts and the expense of an inventor would never be recovered due to free distribution of the invention. Now, it is very imperative to know that an innovative idea must be treated as a secret if an enterprise wishes to appropriate potential commercial benefits from the idea. Thus, intellectual property rights and innovation play a very important role in driving innovation to result in fulfilling our ever-increasing needs today. Thus, we end this entire session of webinar here. Thank you for your time, and I hope I have been able to touch upon the topic and we look forward to your participation in our future events as well. If you have any questions, you can log on to our website or send us an email or call us and we can help you with your query. So thank you so much for your participation.